Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I'm joined by Miki Matrician, co-managing partner of WR Immigration's Boston office. How are you today, Miki?
I'm good. Hi, Kimberly. How are you?
Good, awesome. I'm excited about our topic today because a lot of questions keep coming up. As a lot of our viewers might know already, we do benchmarking surveys. And in response to some of these benchmarking surveys, people provide us with their pain points. So we are able to use that to help guide our clients. And one of the pain points that came up this time around is that many corporate immigration professionals noted that some of their concerns is making sure that they are in compliance with immigration laws and regulations, given the lengthy processing times for the permanent resident or i.e. green card process, as well as the increasingly remote nature of the workforce at this time. So changes in jobs, such as promotions and worksite locations, are totally part of an individual's career progression, right? We see it all the time with employees. But when that employee is a foreign national, these changes can really have an impact on both non-immigrant status, such as the H-1B classification, as well as the permanent resident process, which we all know as the green card process. So with that lead in to what our topic is today, Miki, let's start with the non-immigrant process. Okay, so many professional employees that are foreign nationals are employed pursuant to probably one of our favorite classifications, the H-1B for specialty occupation employees. And with many companies offering remote work or at least hybrid option to work today from home, part-time, and then in the office other days of the week, what additional concerns does this raise for your HR professionals?
Yeah, so with the H-1B, the employer has compliance obligations related to what's called the labor condition application that's filed with the DOL, the Department of Labor. And so after the H-1B is approved by Citizenship and Immigration Services, if the terms change after the approval, HR might need to take steps to make sure that they stay compliant because now the terms have changed after the approval, right? So the H-1 visa is specific to the position and the location of improvement that was approved. So if there's a material change, like a change from full-time in-person at the office to remote or hybrid, that's a change of location, and that's a trigger for HR to engage with counsel on any necessary compliance steps.
Okay. So what if the employee works remotely from home and is moving out of state to a new home and will continue to work from home from that new location? Assuming HR knows in advance of such a move, what guidance do you provide to HR?
Yeah, so ideally, HR is alerted by the business, the manager, or the employee before the move happens. If an employee moves out of state, then HR would have to file an H-1B amendment with the USCIS. And, something to know is that the wage obligations could be affected. It might be different now. So that's something to expect and work on with counsel.
Okay. And you mentioned filing an H-1B amendment. Does the employee need to wait for the H-1B amendment to be approved before they can actually move and start working in the new worksite location?
So no, the employee can start legally working from the new location once the H-1 amendment is filed. There's no need to wait for the approval, unless, of course, the company has a specific policy requiring the approval to come through before relocating.
Okay. Good things to consider. So now we're going to shift over to an employee is working from home and they change their residence, but this time, let's say they're moving from Boston to New Jersey, right? Completely different MSA. And in this situation, HR is informed only after the move. There's no advance notice. So what issues does this raise for the foreign national employee? And what discussions do you have with your HR clients?
Yeah, so that definitely creates an issue. And that was not uncommon in the past few years for HR to find out after the fact. Particularly in COVID, when so many people switched to complete remote, work arrangements overnight. A lot of employees didn't know of the implications of a location change. And so they moved across the country without letting HR know. So basically what happened was companies had to scramble to file all these H-1 amendments once that information came to light. Sometimes that meant that employees had to leave the US to get their visa stamped abroad to effectuate that H1 change in the terms in the amendment. And that, sometimes created more complications.
Great. So while HR professionals need to be aware of these worksite changes, right, for H-1B employees specifically, are there any other non-immigrant work authorized classifications that are impacted by an employee's change in the worksite location?
Yeah, it's good for HR to be aware of those other visa types, as you mentioned, for H1B ones and E3s in addition to H1Bs. So those are visa statuses that, just like the H1B, are specific to the location as indicated in the approved petition. So that's something that's very important not to forget about those visa categories. But even for visa statuses that don't have the LCA requirement, like, for example, the L1, some employers we find want to file amended petition to reflect the new location to avoid potential issues in the event of a DHS site visit, for instance.
Yeah, that's always, good advice, especially if someone is a little concerned or has issues at the port of entry. Our next topic that we're going to throw out here is what about, one of our favorite things like promotions or job changes within the same organization. So if a foreign national employee is going to be promoted and they are in H-1B status, for instance, what advice do you provide when you communicate with your HR and global mobility professionals about that particular individual's strategy, or are there even any issues?
Yeah, so when we're reviewing immigration matters with HR, we're discussing any anticipated changes that are upcoming in jobs. So not only in the job location, but also promotions. And promotions are, so exciting for people, but we want to make sure that compliance is not forgotten. So we usually have a planning strategy around the time that the company is, about to conduct their annual reviews or biannual reviews and promotions. And so for non-immigrant visas like the H-1B, if there's going to be a substantial change in the job duties, an amended petition might be necessary. Also could trigger, a new classification in terms of promotion to a manager level from an individual contributor level. So we need to kind of look at the details of what the changes are going to be. And just like with the location change that we mentioned earlier, the amended petition does need to be filed prior to the change in the job. So it does require coordinating with HR in advance to make sure the amended filing is aligned, but it doesn't need to be approved before the change becomes effective.
Let's shift a little bit from non-immigrant to immigrant, the green card process, right? A lot of non-immigrant foreign national employees are also beginning to go through the permanent resident process or are already knee deep in the permanent resident process. And they may have been in this process for a couple of years, or at least that they just started. So how do you guide your HR clients when advising on potential promotions and or work site location changes if a foreign national employee has a permanent resident process either under draft or pending with the government?
That's really important not to forget about the cases that are, related to permanent residence. So when we go over job changes or worksite location changes with HR, we're looking at not just the visa status that's non-immigrant, but also the green card case that's underway, as a draft or pending with the government agency or already approved. And so the permanent resident process that's most affected by those types of changes is the perm labor certification application. And the perm is very specific to the position and the work location. And so if there's going to be changes to either one of those, we have to look at what stage of the process are we in to determine the impact and what strategy should be implemented. Sometimes a new perm application might be necessary.
We never want to do that if we don't have to, but sometimes it's unavoidable.
Okay, so Kimberly, turning to you, can you tell us about how you talk with HR clients and what advice you give to them about how to be proactive about changes in worksite locations or promotions?
Yeah, sure. So communication and education are key, and not just for our HR professionals, but also for the sponsored foreign national employees and for managers as well. So we partner with our HR counterparts in order to make sure that employees know that it's really important for them to notify HR as well as WR Immigration prior to any change in worksite locations, including a switch to remote or hybrid work. It's not that we're being nosy, it's that it's really important to make sure that the company is in compliance and that the individual's non-immigrant classification is protected as well. So this includes, providing an update prior to a change of residential address. It's also important that managers are educated because they're conversing with, their employees on a day-to-day basis. So if they understand that there's an issue or a potential issue with the job change or a work site change, they can bring that up to HR or to the legal team in advance before potentially discussing it with the foreign national employee and try to get a game plan in place to understand what kind of impact that has. And that's been very beneficial because then everybody is on the same page and we don't have these, oops, we can't, have you promoted at this time or you can't move at this time, right? We don't ever want to prohibit somebody from advancing in their career. So it's really important to communicate and get that advanced strategy in place. We also utilize technology by integrating Rapid with some of the HR information systems so that Rapid can flag any changes based on the data feed from the HR system. So this helps us in HR to immediately see changes to the employment that may need compliance action items and provide notifications of change of address. So any way that companies can leverage, technology to help with this, especially if there's a very large foreign national population, that's always beneficial. So I think that's a wrap on our discussion today about immigration and the impact of job changes and worksite locations. So if anyone has any questions, please post a comment or send us a message. And if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe the live stream and post it weekly in a newsletter so that you can subscribe to that as well. So the link to subscribe is in the comments. And with that, we're wishing everybody a wonderful week. Good to see you again, Miki.
Thanks, Kimberly. Have a great week.